This is the American Law Journal.
Are injured workers losing the medical battle? Well, the way cases are settled nowadays and a new law that may go on the books, you bet they are. Good evening and welcome to the American Law Journal. I'm attorney Christopher Naughton, and there was a time when you couldn't settle your case in workers' compensation, and now you can. That sounds like a good thing, right? What happens when the money runs out and you still have medical bills? The legal intelligencer's Gina Passarella has this.
Call me right now, 459-CASH, 459-CASH. I'm waiting and ready to go after your award.
You've seen personal injury commercials, right? Get injured, file a lawsuit, settle. But a work injury is not a personal injury. Under workers' comp, there's no award for pain and suffering. You only get a fraction of your wages. And settling your workers' comp case can be trickier.
Once you settle your workers' compensation claims, you cannot have your case reevaluated or open that case back up. The one more common exception is if your settlement includes open medical benefits.
Open ongoing medical benefits today are rare. Lawyers and judges tend to settle almost everything, and that, some lawyers say, can be a problem.
Years ago, the medical aspect would always remain open. So what has been happening over the course of several years is the claimants are enticed to settle the medical aspect of their claim. I mean, the concern is that within a year or two, there's no more money, and they need medical treatment for a severe work injury, and the concern is how are they having that medical treatment paid.
I think all too often medical gets brushed aside.
Claimant's attorney Christian Petrucci says in a settlement, lawyers must be adamant about the value of their client's medical benefits.
In the cases where an injured worker needs medical, that has to be on the table, and oftentimes I will ask for a life care plan, which is an expert report designed to demonstrate the value of the future medicals. And if that's an element of the settlement that has to be presented, whether it's part of the insurance company's economic reality or not.
In the end, injured workers should never feel forced into a settlement. Trust your instincts, your lawyer, and the judge.
I think anybody can find an individual case where they don't want to settle and maybe they're feeling pressure to do so by the system. But in the end, it's really up to the parties. Do you want to settle the case or not? The judge is not going to make a claim and settle a case if they don't want to.
For the American Law Journal, I'm Gina Passarella.
Settlements become all the rage in workers' compensation. Is that a good thing? Let me ask my four guests. George Beatty weighs in tonight with Beatty, Sloan & DeGeneva, over 25 years, representing claimants in personal injury matters, including medical malpractice, products liability, and, of course, workers' compensation. Jeffrey DeLynn, the Honorable Jeffrey DeLynn. Judge DeLynn, for many years here, 10-plus years on the set. Judge DeLynn weighed in because we had invited him, and he was gracious enough to accept our invitations as a seated member of the judiciary, a workers' compensation judge, now a partner with Krasno, and Owen Dinjo in Philadelphia, Pennsylvania, also representing claimants. And Barbara Young is with us for the first time with Schaff and Young, also centered in the Philadelphia region. She represents the insurance companies, the employers, and the third-party insureds. And the judge on our set tonight, the current judge, the Honorable Audrey Beach, joins us again this evening, and it's been a while since we've seen Judge Beach, seated in the greater Lehigh Valley, correct, Judge?
That's right.
And as a seated judge, do you go to any other areas, or you pretty much, your courtroom is there in the Lehigh Valley, and that's where you're placed?